Thanks again for joining us, everybody, and welcome. And just do a real quick recap of what we covered last month. And last month it was we reviewed a chapter titled "The Municipal Colonies of America." And after going through the U.S. Supreme Court's machinations in the 1819 Dartmouth College case, in which the judges changed the corporate charters of business corporations from temporary licenses for investors to do business into a binding contract between the people of the state that issues the charter and the incorporators. And we also found that the Supreme Court stripped municipal corporations of their authority as governing bodies representing local communities. And then we looked at the legal theory called Dillon's Rule that weaponized the court's assault on local governing powers and made every municipality in the nation subordinate to the sovereign power of for-profit corporations. We saw how the American revolutionaries had a diametrically opposed plan that centered the hoped-for new nation's political system around the rights of community self-governance. And finally, we considered the irony in the design of the flag for the Federalist Party's top-down form of government codified in their counter-revolutionary U.S. Constitution. That banner, the stars and stripes that are so revered these days by self-proclaimed patriots, was modeled after the emblem of the British East India Company, against which the American revolutionaries raged for taking huge tax breaks from the crown, and then the crown billed the colonists in higher taxes to make up the difference. You may recall that it was the East India Company's tea that was dumped into Boston Harbor. So tonight, we're going to focus on the publicly chartered, publicly licensed, and publicly permitted so-called private business corporation, and how corporate property came to replace the 3/5 clause nullified by adoption of the 13th Amendment that ended chattel slavery. The 3/5 clause gave legal owners of human property greater representation in the House of Representatives and the Electoral College. And in effect, the 3/5 clause turned enslaved Americans into privileged property in which greater political representation was vested and conveyed to their purported owners. And tonight we're going to consider how vesting greater political power in corporate property, similar to how it was vested in enslaved people, conveys that power not to the corporate property, but to the owners of the corporation. And as such, these political powers vested in corporations replace the injustices instituted by the 3/5 clause and overturned by the 13th Amendment, except for on a vastly larger scale. And so the title of this chapter, which, by the way, in the book is actually chapter 6, is called The New 3/5 Clause. And as I do with each of the chapters, I start with a quote. And tonight's is from Adam Smith. You may remember that name. He's the author of the famous book, which was The Wealth of Nations. And most people know The Wealth of Nations as a volume that is kind of the Bible for capitalism. But if you actually read it, and I kept away from it for so long, for many years, because I thought, I don't want to read the capitalist Bible. But if you read it, you find out that Adam Smith was a real critic of corporations and of concentrated wealth and a lot of other things that we talk about. We could probably use quotes from Adam Smith to make our case against the system that we have now. So here's just one of them. Here's the quote. Civil government, so far as it is instituted for the security of property, is in reality instituted for the defense of the rich against the poor, or of those who have some property against those who have none at all. That doesn't sound like a raving corporatist, does it? So at any rate, we'll dive into the text, and what we'll do after each section, I'll stop and ask if there are comments, questions, anything you want to add. So the first subsection in the chapter is titled 200 Years of Chartered Injustice. Evidently, you can make this stuff up. So historians have called the American Civil War the Second American Revolution, also the Bourgeois Revolution, and the Corporate Revolution. By whatever rubric, its end marks a watershed moment in the ascending fortunes of wealth toward the pinnacle of power in the United States. Huge tracts of federal land were transferred from public ownership into the private possession of corporate investors, thanks to the war debt owed by the federal government to the railroads, arms and textile manufacturers, coal barons, and especially the banks. Political paybacks also transformed the federal judiciary and the U.S. Senate. They were suddenly bursting with corporate lawyers after the war. Under that new proprietorship, the Supreme Court exercised astonishing boldness when it unexpectedly discovered, in air quotes, corporations in the Constitution where they're never mentioned. In 1886, the Santa Clara County versus Union Pacific Railroad Corporation ruling declared without precedent or argument that corporations are to be treated as persons and afforded protection of the law equal to any human being. That opened the door for more than a century of legal victories for the propertied class that culminated with the infamous Citizens United and Hobby Lobby decisions. Once the door was open and robed men and women of the court with nothing but the force of their opinions amended the Constitution and transformed the nation from a nominal republic into a de facto plutocracy. In 1866, Congress approved the 14th Amendment and sent it to the states for ratification. Then in 1868, three-quarters of the states did just that. They ratified the 14th Amendment. And in 1886, the Supreme Court amended the amendment using the Santa Clara County case to to declare that where the 14th Amendment says, quote, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, end quote, the word person applies to chartered corporations too. That meant that beginning on May 10th, 1886, and forever after, it would be unconstitutional for any state to deny corporate property the same legal protections given to people. So let's unpack that a bit. So remember that 67 years earlier, the Supreme Court decided in the Dartmouth case that we talked about last month that a charter of incorporation would no longer be a grant of certain commercial privileges from the whole of the people to a few members of society desiring to establish a business corporation. After February 2nd, 1819, every charter became a legal contract between the people of the state and the people receiving the charter. The Dartmouth decision declared that after the charter was publicly issued, it immediately became a matter of private law, and it would be unconstitutional under the contract clause for the state to impair the obligation of contracts, as the contracts clause puts it. No state may impair the obligation of contracts. That is what the contracts clause says. And if the charters are now contracts, no state that issues a charter can then change the charter, revoke it, or do anything to interfere with it. When in 1886, the court declared that corporations are persons deserving the protection of the 14th Amendment's Equal Protection Clause, the contracts, or the so-called contracts, between the people and the incorporators of every corporation in every state were altered. The court's Santa Clara decision contractually obligated the people of the states issuing corporate charters to conditions they had never agreed to. Without discussion, the court declared that contracts in the form of corporate charters would now bind the people issuing the charter to recognize their corporate creations as persons with unalienable rights. The states were simultaneously preempted by the contract clause from impairing court-mandated terms of the contractual charter and from making laws that deny corporations the same legal protections as citizens. The people were involuntarily bound by these so-called contracts, and they were never consulted about the change. After the fact, the people were excluded from governing their corporate creations because contracts are within the province of private law, not public law. And so, under private law, which is corporate law and contracts law, the people are not allowed to use their legislatures to alter any agreements made in the private sector. Chief Justice Morrison R. Waite presided over the Santa Clara case. The dispute in that case was over taxes and whether Santa Clara County, California, could tax the Union Pacific Railroad at a higher rate than the county taxed people. The court said it would violate the corporation's right to equal protection of the law if the county's tax stood. It would, in fact, be unconstitutional discrimination and a violation of the corporation's civil rights under the 14th Amendment. Our history demonstrates that the court has been reluctant to exhibit anywhere near the level of homage to the rights of flesh and blood persons as it does for corporations. There's some irony in the fact that Judge Waite had also presided over a case in 1874 in which Virginia Happersett of Missouri argued that as a citizen of the United States, she had an equal right to vote as a woman, protected by the new 14th Amendment. That's the same amendment used 12 years later to rationalize ersatz personhood for corporations. Judge Waite replied to Ms. Happersett that, quote, "Our province is to decide what the law is, not to declare what it should be," and he dismissed her claim that she should be allowed to vote, even though she was a woman, not a man. And the irony is that then just a few years later, Judge Waite did not decide based on what the law is. He made up a new law and said corporations are persons under the 14th Amendment. In 1896, the court further amended the 14th Amendment when it decided that although it had been ratified to guarantee equal protection of the law to freed slaves, states could constitutionally segregate African Americans from so-called white Americans. With the Plessy versus Ferguson decision, racial discrimination became constitutional on May 18th, 1896, 10 years after the court made it unconstitutional to discriminate against corporate property. So not until May 17th of 1954 was this irrational and bigoted decision overturned in Brown versus Board of Education of Topeka. By contrast, during the intervening 58 years, corporations enjoyed the protection of the Constitution. They continue to do so. Since 1886, it has been unconstitutional for the states that charter corporations to discriminate against them. Meanwhile, the struggles of flesh and blood persons for racial and gender equality, for democratic rights, for protection against corporate assaults continue with institutional opposition from government. The privileges of the propertied class are shielded from governance by the people through preemption, the privacy of contracts, ceiling regulations, federal hegemony over interstate commerce, and the privatization of government by dissembling judicial decisions backed up by the coercive power of public law. That's the law the people supposedly govern with. Not to mention, by the way, that the privileged wealthy class are also protected behind the corporate shield. They're shielded from liability for the actions that they use their corporations to instigate. So I'll stop there for a moment before I go on to the next section and ask if you have any questions or comments or any additions to what I've covered so far. If you want to
If
just
nobody
type in.
else has a question, I'm still fuzzy on contract versus charter. I'll have to read it a few more times. But so how did the kids from Montana win, basically, then? I could not believe it, and I don't get it.
Well, not so much win, but they're told that they can actually go to court and they're not going to be thrown out of court because they have standing. What the court found is they have standing. In other words, they have a valid grievance over the government because that's who's being sued. The defendant is the government for not protecting them from the climate change and not doing something about industrial activities that do harm to the climate. So what's happened so far is that the young folks' complaint has not been summarily dismissed. Now, when they go to when it goes to a trial and they make their arguments, the government is likely, or the attorneys for the government are likely to argue that, well, the corporations that put those toxins into the air are legal persons with constitutional rights, and we don't have legal authority to stop them from doing certain things with their own property. I mean, I'm just saying that that's, in very general terms, one of the arguments that could be made, and there'll be others that can be made as well. But when you ask about the contracts clause and the contractual nature of corporate charters, I have to say I'm not surprised that it's hard to understand because it doesn't make any sense. But that's what the courts decided in 1819 in the Dartmouth case. There are a lot of things that I can't make sense of for you, like corporate personhood, because, at least in my opinion, they're without rational foundation. And the courts are supposed to make decisions based on what the law is, not what it should be, as Morrison Waite told Ms. Happersett when she tried to point out that under the 14th Amendment, she had equal protection of the law, the same as any male American. And Justice Waite said, "Oh, no, you don't. I don't get to change the law. So the law has been women can't vote. I can't change it. I'm just a judge." And then when it came to the Santa Clara case, even without anybody asking the court to do it, even without legal arguments, and absolutely no precedent, no decisions before that to base their dicta on, the court said, and by the way, corporations are persons under the meaning of the 14th Amendment. So they made it up out of thin air.
Yeah. In Adam Winkler's book, and then I think in your book too, and I also read Jill Lepore's recent history. Roscoe Conklin basically lied and said, well, because he was on that committee and he was the only living member of that committee that was making that original thing up, and he basically lied and said, well, it's not citizen, it's person, and corporations are persons.
Right. He lied. And that was probably, I mean, I can only guess, but based on a lot of other information in the history, it was probably an intentional lie to get the outcome that was created. And there are a number of good books on it, but not many, quite frankly. Winkler's book is pretty good, and he does it. He wrote the book a little bit tongue in cheek, using the metaphor of a corporate person trying to win its civil rights, like it was an African American or a woman trying to get recognized as having their rights under the law. But of course, property can't argue for its rights because property doesn't have a voice. But now it does under Citizens United because money is speech. And by the way, that was another law that was invented by the court. Money is a substitute for human speech, and it expresses the opinions of corporate persons. But of course, we know, because we don't live in a fantasy world like Supreme Court justices do, we know that property can't express an opinion, nor can it have religious beliefs. But under the Hobby Lobby decision, oh yes, it can. So we're living in a fantasy world now, and it's not just the recent, the past presidential administration that's been living in a fantasy world and living in a post-truth culture. We've been living in that culture for a long time, and we're just seeing kind of. I think that probably we're seeing what happens when you start there, you end with natural consequences, with people who take the reins of power and don't pay any attention to facts, truth, morals, or ethics. None of it matters because that's apparently the direction the culture has decided to go. Hanuman, you have your hand up, and I'm sorry that I didn't notice it sooner.
Okay, thank you, Ben. So what's with the courts? What are we supposed to do with them?
Well, we have, and I don't know that most Americans know this, but we have the only Supreme Court in among the what we call democratic societies that has judicial review powers. Judicial review powers the court gave to itself back in the 1812, I think, was it? Maybe David, you recall the date exactly. My brain isn't giving it to me, but the court decided that when it came to laws passed by Congress, representatives of the sovereign people, that the Supreme Court had the last shot at it, to look at it and decide whether the laws that were passed were constitutional. And that certainly gave them monarchical powers. When you think about it, if there had been one Supreme Court justice instead of 9, that the power to veto the laws of Congress would have been very clearly a monarchical power. And it was the intention and the wish of the Federalists who drafted the Constitution. We talked about this earlier on in earlier sections of the book. They really wanted to put a constitutional monarchy in place, but didn't dare do it because the regular folks who fought the revolution would have come out and kept fighting against that idea. But in effect, the Supreme Court is a monarchical power that gave itself the authority to veto decisions made by people elected by those with authority to vote and participate in governance. And by the way, originally that meant only white men with property. It did not include women or African Americans or Native Americans or white men without property in most states.
So do you have any suggestion to what we can do about this?
I don't, personally, I don't see any solution to it but to change the form of government, to change the powers and authorities of the Supreme Court. In the first Pennsylvania Constitution that was drafted and enacted in 1776, was one of the very first state constitutions. And it was also the most democratic of all the constitutions ever enacted in the United States. It did not have a Supreme Court. It had what was called a council of censors. And the council of censors was composed of citizens appointed from each of the counties in the state. And the Council of Censors would be assembled every 7 years, and they would have a look at the laws passed by the state legislature and decide whether they were constitutional or not. And if they weren't, they could essentially overturn them. And they could also propose constitutional amendments and put them on the ballot for people to vote on in order to correct things that weren't going right based on the original intent of the Constitution as it was enacted. It was an interesting system. It was the citizens going back and having a look every so many years to see if their government was still on track with where the revolution intended it to be. In 1838, or actually, I'm sorry, in 1790, the Pennsylvania Constitution was overturned. And the argument was to make it much more similar to the federal Constitution that was passed, enacted, ratified a year before. And so the Pennsylvania Constitution lost its strong democratic bent, and they lost the Council of Censors and gained a Supreme Court and a governor who could veto the will of the people through their representatives as well. When I say that the Federalists were counter-revolutionaries, I mean they were counter-revolutionaries, and that's why we have a Supreme Court like we do now.
Thank you.
Thomas Jefferson thought, and we talked about this a couple of chapters back, but in about 1820, he suggested that because the way the Commerce Clause was used to veto the decisions of the state legislatures, he thought that it was about time for a change of the Constitution and a new revolution. Any other comments or questions? All right, then we'll move on to the next section, and it's titled "Corporations Are Not the Problem, the Diversion of Personhood." Corporations aren't the problem. We talk about them, and I know I do. It sounds like I'm saying corporations are the problem. But corporate personhood has gotten a lot of attention ever since the Supreme Court's Citizens United ruling. The 2010 case built on decisions made by politically appointed judges over nearly 2 centuries. It expanded the ways corporate property can convey enhanced political clout and immunity from public censure to its owners. But let's be clear, corporations don't spend money on elections. The truth is that specific people use corporate property as conduits through which they spend large quantities of money to control the outcome of elections. They are privileged with power over and above the rest of us because they're not held to account for their actions. They are above the law thanks to the privileged property they possess and the shield of corporate immunity from liability. Only a fanciful suspension of reality could allow the Supreme Court to conclude that the First Amendment is applied equally when corporate managers are allowed to control political discourse by purchasing it in the name of the corporate person they own. Talk of corporate personhood diverts us from noticing that it is wealthy human beings, not property itself, who receive from the court the privilege to decide who will govern. The Federalists did their worst to violate the ideals of the Revolution when they vested the right of representation within the chattel property of slaves via the 3/5 clause. When the 13th Amendment overturned not only slavery, but the 3/5 clause along with it. The imperious Supreme Court was quick to replace the property to elites' lost political advantages. The antebellum Constitution that had lodged extra congressional and electoral college representation for plantation plutocrats in their chattel property was put back on track when the court vested political rights in corporate property. Where the enslaved human once played the role of privileged property, the corporation now fills the bill. Vesting rights in property effectively removes the constitutional right to a republican form of government from a majority and creates political advantage for a favored wealthy few. Today, because the Supreme Court vested rights intended for everyone in corporate property and granted the property class the power to fund campaigns through their corporations, all elective positions of power are available for purchase by the wealthy investor class. It's a better deal for the 1% than the plantation owners got when the Constitution was first ratified. According to James Epperson, quote, in the 1950s, only 2% of American families owned corporation stocks equal in value to the 1860 value of a single slave. Thus, slave ownership was much more widespread in the South than corporate investment was in the 1950s America, end quote. Today, stock in corporations is more broadly distributed than in the 1950s, but control of corporations and how they spend money, how they speak, according to the Supreme Court, to influence election outcomes is not. According to Rob Weil of Money Magazine, quote, the top 10% of American households, as defined by total wealth, now own 84% of all stocks in 2016, according to a recent paper by NYU economist Edward N. Wolf, end quote. Prior to 1865, the slave was not responsible for depriving white men in the North of their right to equal representation in the federal government. The men who crafted the Constitution's 3/5 clause were responsible, and the political imbalance they created resulted in the Civil War. 21 years after the end of that national fratricide, corporate lawyers presiding on the Supreme Court engaged in mutation through interpretation of the 14th Amendment and filled the void left by revocation of the 3/5 clause. Those ideologically driven men are responsible for the resulting violation of public political rights that now exceed the damage done to democratic aspirations by the 3/5 clause. And every political appointee to the court who has added to the rights vested in corporate property over the ensuing years is responsible for the deep societal stress now in evidence and brought on by the cumulative injustice of privatizing general rights. Whether or not the Federalists foresaw the potential for turning charters of incorporation into instruments for empowering the property class and disempowering the rabble, it is certain that their revolutionary nemesis, Thomas Paine, understood the tyrannical nature of chartered privileges. He and revolutionaries like Sam Adams knew firsthand how the commercial aristocracy had used charters as weapons of oppression prior to the Revolution. The Revolutionary Sons of Liberty distributed numerous broadsides against the corrupting influence of the great corporations of the era. The true revolutionaries, not the Federalists, understood that exclusive privileges and monopolies were ruinous to general rights. Paine also had no illusions about the purpose of corporate charters. He explained in simple terms that they are legal tools that create advantages for a privileged few at the expense of everyone else. Paine was ridiculed mercilessly in the British press for writing that human rights are an inherent birthright superior to inheritable aristocratic privileges. He didn't rise to the bait of brutal political cartoons caricaturing him, and they called him Mad Tom. And instead, he went straight to the root of the problem. Tom Paine is great for doing this, and common sense that inspired the revolution was a critique of the whole British system of government. But he went right to the root of the problem with corporate charters when he wrote this: I answer not to falsehood or abuse, but proceed to the defects of the English government. I begin with charters and corporations. Interesting that he begins there. Then he dove in saying, quote, it is a perversion of terms to say that a charter gives rights. It operates by a contrary effect, that of taking rights away. Rights are inherently in all the inhabitants, but charters, by annulling those rights in the majority, leave the right by exclusion in the hands of a few. Those whose rights are guaranteed by not being taken away exercise no other rights than as members of the community they are entitled to without a charter. Therefore, all charters are instruments of injustice. End quote. The U.S. Constitution, seen as a charter, operates in the same way through its Commerce Clause and Contracts Clause, and through every word of judicial dicta that transformed public rights into privatized rights under the private law of corporate charters and contracts. The Supreme Court has perpetuated, I should say, and enhanced those privatized rights from one generation to the next. The property class, not corporations, deprives the rest of us of our right to a representative form of government through the powers stored in their privileged property. Property itself does not bear the burden of responsibility. Human beings do. After witnessing the passage of the first 4 presidential administrations, Thomas Jefferson seemed to sense the disastrous detour away from the ideals of the revolution that America had taken. And here's another quote where he makes this case. In 1816, the year the Dartmouth controversy went to court, he wrote that, quote, England exhibits an example of the truth of the maxim that ruin will fall heaviest as it ought to fall on that hereditary aristocracy which has for generations been preparing the catastrophe. I hope we shall take warning from the example and crush it in its birth, the aristocracy of our moneyed corporations, which dare already to challenge our government to a trial of strength and to bid defiance to the laws of their country. This was in 1816. Jefferson saw the equivalence between the British hereditary aristocracy and what he called the aristocracy of our moneyed corporations. He predicted it would all end badly for the people, and that the coming catastrophe would be a direct result of allowing a privileged minority to act beyond the governing authority of the community at large. A year later, even the author of the Constitution's first draft, James Madison, was having second thoughts. He wrote, quote, there is an evil which ought to be guarded against in the indefinite accumulation of property from the capacity of holding it in perpetuity by corporations. The power of all corporations ought to be limited in this respect. The growing wealth acquired by them never fails to be a source of abuse. So in 1817, James Madison, who put together the first draft of the Federalist Constitution, was concerned that corporations were going to insinuate themselves into the system of governance and take control. That was over 200 years ago. Since then, the power of the corporation has burgeoned. Now, let me pause a minute and see if there's any comments, thoughts, or questions on that. I think that for myself, I think that it's remarkable that 2 people that were there during the revolution, and one of them, James Madison, who was there when they drafted the current Constitution, that they thought that it had been a mistake so soon after its ratification. The next section is titled The Contract on America, the Constitution as Forced Arbitration. The federal court has illegitimately contractually obligated the people of every state to involuntarily honor the rights it vested in corporate property. I won't recount the many high court decisions that have, without precedent, handed most of the Bill of Rights to the property class by vesting them in the fictitious personhood of corporate property. For a timeline of those disastrous decisions, see CELDF's model legal brief for the elimination of corporate rights. I think you can find that on our website. And Adam Winkler, who Lynn has mentioned a couple of times, wrote in his We the Corporations, How American Business Won Their Civil Rights. That was a 2018 publication. And Tom Hartman's Unequal Protection, How Corporations Became People and How You Can Fight Back in 2002. If you have a look at those books, they recount, and as well as our model brief on our website, they recount the history of each of the decisions from the Supreme Court as they gave parts of the Bill of Rights to corporations, one at a time, but cumulatively, we're now at a point where corporations have almost all of the Bill of Rights protections. I'm waiting for them to be granted Second Amendment rights to bear arms by the Supreme Court down the road. Who knows, anytime soon. The enhanced immunities from public law that the Supreme Court judges transmitted to the property class through their corporate property include these: legal protection of wealth equal to the unalienable rights of people, procedural and substantive due process of law for wealth involved in legal disputes, immunity of wealth from public governance, amplification of the right of free speech for the wealthy above the volume of public discourse when they use corporate property as the conduit for their opinions, and money is now equivalent to speech. Money redefined as speech, as I say, freeing up the property class to purchase elections and legislation. Freedom for the corporate class to assert religious dogma as a political weapon. Freedom from warrantless search and seizure, including unscheduled OSHA, EPA, and other inspections to guarantee compliance with public regulations. Now, a warrant is necessary. There can't be any surprise visits. Freedom from freedom from double jeopardy, regardless of judicial error or post-acquittal discovery of guilt. Freedom from government takings of property, including permits and licenses, hypothetical future profits, and access to resources, regardless of what harms that access might bring about. Liberty of privacy, including the right not to disclose ingredients of foods, components of toxic industrial materials, production of papers and correspondences that would reveal incriminating evidence of malfeasance and lawbreaking and perjury. And also the freedom to face an accuser in a court of law and deduct legal expenses as a cost of doing business. It's an understatement to say that the modern business corporation is the preeminent form of privileged property. The question arises, did those judges on the Supreme Court honestly interpret the Constitution when they determined that corporate property is a person deserving the same rights as people? Or were they dishonest in their rulings and simply granting privileges to the rich indirectly by bestowing immunity from public governance on their privileged property? In 1886, Santa Clara case that created precedent for corporations being treated as legal persons, that opened with Chief Justice Morrison R. Waite declaring prior to oral argument that, quote, the court does not wish to hear arguments on the question whether the provisions of the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We, all of the judges, are all of the opinion that it does. So nobody asked the court to declare corporate property to be legal persons. They just said, we're doing it. A persuasive argument has been made that the Southern Pacific Railroad's legal representative in that case, Roscoe Conkling, who at the time was the last living member of the drafting committee of the 14th Amendment, deceived the court into believing that the intent of the committee was to include corporations under the meaning of the word person in the amendment. The details of the controversy are beyond the scope of my book, but the court's clearly departed from reliance on precedent in coming to its unsupported conclusion. Another book that you might have a look at for further discussion, and it's a good one, I suggest Howard J. Graham's book called Every Man's Constitution, Historical Essays on the 14th Amendment and the Conspiracy Theory. And the Conspiracy Theory of American Constitutionalism. That book came out in 1938. In that same year that book came out, in 1938, Supreme Court Justice Hugo Black wrote, quote, "In 1886, this court, in the case of Santa Clara County versus Southern Pacific Railroad, decided for the first time that the word person in the amendment did in some instances include corporations. The history of the amendment proves that the people were told that its purpose was to protect weak and helpless human beings, and were not told that it was intended to remove corporations in any fashion from the control of state governments. The language of the amendment itself does not support the theory that it was passed for the benefit of corporations," end quote. I'll pause there to see if there's any more comments or questions. I think there's comments in the chat. I'd be honest, I haven't been able to follow the chat comments.
If you want, I can, highlight some of that for you. So there's a question. You mentioned a 1938 book, and someone's asking for you to repeat the name and the author again.
Sure thing. The author is, just a second here. The author is Howard J. Graham, Graham. And the book is called Every Man's Constitution, Historical Essays on the 14th Amendment, the Conspiracy Theory, and American constitutionalism. That conspiracy theory, by the way, is the idea that when the court says they found corporations in the Constitution through the 14th Amendment, that it was a conspiracy to hand over political power, immense political power, to the wealthy class. I'll have to say too that Graham's book is, I don't know if it's been reprinted in any recent years. I had to search for it pretty diligently, and it was also a little expensive to purchase, but you might go, I think you might go to Google Books, I think it is, and they archive books that copyrights have expired, and this may be one. You may actually find a PDF version of it online for free. So I would suggest that. Okay, someone else has joined us. Welcome. Who's here? Margaret, welcome. I'm going to move on to the next section in the chapter, if there are no comments, questions, or additions. All right, the next section is titled Rights Vested in Property Privatize Civil Rights. As soon as an employee parks the car in the lot outside and enters through the door to the workplace, she leaves her civil rights in the glove compartment. Settling into her cubicle, she notices an email from the personnel department. She's informed that the online search she did during her lunch break the previous day is a violation of company policy and an unauthorized use of corporate property for personal business. A note of reprimand will be entered into her file. Her right of privacy has not been violated, according to the courts, because the corporation that employs her is not, according to case law, a state actor and is not capable of violating her rights, even though it was created by a state-issued charter and licensed to do business by the state. Across town at another state-chartered organization, a warehouse worker is pulled aside and instructed to report to the office for a random drug test. His employment is on the line if he refuses. His Fourth Amendment right against warrantless search has not been violated according to court precedent. The corporation is not considered a state actor by the judiciary, and on corporate property, the owner of that property has full rights to command its employees. According to the courts, her First Amendment right of free speech has not been, skipped a little bit here, across the continent. Another example here, in a factory that molds plastic into bumpers for the auto industry, a worker on the line nods to a coworker and says, "Maybe we need a union." Minutes later, she's standing in front of the vice president's desk being told that there will be no talk of unions on the job. According to the courts, her First Amendment right of free speech has not been violated for the same reason the rights of the other employees were not. Only the state and not private actors can violate rights because private actors are, in the case of corporations, wealthy people in possession of private business corporations. They own privileged property. They are immune from responsibility for violating rights. The law says they are not capable of infringing on the rights of employees. Now, I'm not going into a lot of legal detail here, but there was a case in the 1880s called the Civil Rights case, in which the court decided to define how rights could be violated. And what they said was, only the state can violate civil rights. Private citizens cannot. So when the Ku Klux Klan would lynch a Black person, they might be committing murder, and that's a crime, but they were not violating the civil rights of the person they hung, according to that court decision, because only a state actor can violate civil rights. Corporations, the court decided, were legal persons, even though they were created by a state, by the issuance of a charter and licensed by a business license and permits issued by the state. The argument is that that is not a state actor. It does not act on behalf of the state or with the state's permission. But we know that that is a fantasy. And so I'll just continue on here a little bit. A week later, the woman who mentioned the term unions on the shop floor, she's required to attend a special meeting where management presents its arguments against workers unionizing. It's a mandatory meeting. And no, her First Amendment right to free association has not been violated in this case. Even the National Labor Relations Board, the regulatory agency that mediates disputes between employees and employers, informs her a few days later that she has no case for a civil rights violation. The corporation has a First Amendment right to lobby employees on the job to oppose collective bargaining. Workers have no right, while on corporate property, to campaign for unionization. And so free speech rights and free association rights belong to the corporation, but not to the employees when they are on the job. So when you enter your workplace, keep in mind that you leave your civil rights, your Bill of Rights protections out in the parking lot in your car. Another right the employees don't have on the job is the right to participate in corporate business decisions. The people who will make the products and produce the added value to raw materials have no say in what will be produced or whether the raw materials will be extracted with environmental, community, and worker safety in mind. They'll not be consulted about hazardous materials that will become part of the product or be used in its manufacture. Once chartered, the corporation becomes a sovereign entity independent of the state that made it. The chartering state and the sovereign people of that state have no say in the corporation's internal governance. This is how private law subordinates the unalienable rights of people, and public law has no authority to check the abuses of private power. Those abuses are legalized by ownership of privileged property. The human beings pulling the strings behind the corporate curtain are protected from liability by the rights of property. It's difficult to understand the acquiescence of so many of us to all of this over the years. Any thoughts or comments or questions? All right.
Yes.
I'm sorry. Yeah.
Yeah, from what you're saying and from reading your book and the other references, it just boggles my mind because when I think about people who join the military, they give up all their civil rights or rights as a citizen. They're under a different jurisdiction or something, so they have their own courts for recourse, or actually they get punished by their legal system. But for us as workers, we're even worse off than somebody that's drafted or enters the military. It's really shocking.
It is shocking. And I don't say any of this with a hint of glee. It really dismayed me to learn all of this that I put together in this book. And the reason I did it was because, as a kid growing up in Philadelphia, I thought that was the birthplace of liberty and democracy. And what I've been talking about comes from personally trying to figure out why the communities that asked for CELDF's help, when I went in to help organize them to protect their communities and their rights and their health and safety, and they were told by their elected officials, wish we could help, our hands are tied, can't do it, we're preempted, we're stopped. The corporation has rights and municipalities don't, because we're public corporations and they're private corporations, and there's a difference. The way that became true, the way that our municipalities became mere property of the state, and the people living in those municipalities became mere tenants living in the jurisdiction, not citizens, and having no right to local self-government. Dillon's rule says there is no right to self-government at the local level. I was shocked to learn that. In some ways, it's hard to believe. And I was even more shocked to think that no one had brought it up. There weren't shelves full of books about the injustices that this system brought about. And I'm further shocked that people who were my allies in opposing, just to be frank, things like the military draft, when I was eligible for that during the Vietnam invasion, and the inability of people to protect their communities, I was completely mystified by how these things could happen under the system of law as it was described to me through the education that I got. And it took digging in and finding that history was more legend than truth. I could say lies, but it was more like reading or watching the Disney version of history than it was anything else. It was certainly not true history. And the reason for getting this out and sharing it with you is because I hope that other people will understand this and act on the knowledge, and fill in the places where I haven't been able to explore, or correct the things that I didn't quite get right. But this isn't a history that's been shared, and it needs to be shared. And when folks like Adam Winkler write his book, he certainly dug into the idea of corporations and where their rights came from, and in an entertaining way. And I think that How Wealth Rules is not written in that with that kind of a tone. I know it's crammed with information and facts that can make it a little bit more challenging to kind of internalize the understanding of what actually happened. But I think all of this information is important. And as much of a challenge as it may be to internalize it and understand it, I don't think that it's possible for us to confront the injustices of today's American world unless we understand at least the basics of this stuff. Because we're going to try to cure symptoms instead of the causes of the problem.
Ben,
Yes.
Since I've known you and the whole CELDF way of explaining these things, so many times, and I think you'll agree, so many times, and more often than not, the public doesn't want to buy into this. Is that a fair statement?
It's a very fair statement. Absolutely.
And you know, I've been involved probably for 20 years at least. And what is the mindset of how it can be explained where more people get the grasp on the whole situation? I mean, I know Chad and I've talked about this 100 times, and you know, I just don't have the mental capabilities of deciding how to do that. But it's really bothersome when you go to a community and they don't want to buy in it. They want to keep doing what they think they have to do under the government laws.
You know, Dave, I think that there's a lot of psychology involved in it. And when you're doing the organizing, you learn some of that. And it's not just that people are obstinate and won't change their minds. I think it's a human characteristic to not change your outlook on the world overnight and not accept, just because somebody says so. The fact that I say so shouldn't change anybody's mind. I put a lot of footnotes in, and I gave sources and all of that so people can explore what I explored to figure out all of this stuff. I'll admit that I connect some dots because they're not connected. A lot of the information here comes from sources all over the place. So there's a little piece here, a little piece there. And not many people are as, I guess, masochistic as I am, and willing to dive in and pull all of that together and try and see where they connect and what, oh, this happened to this year and this happened 2 years later. And is there, that followed naturally? It makes sense that it came right after, but nobody ever put them together chronologically for me to understand. That Dillon's Rule came right after the Civil War, when corporations were on the rise and slavery was no longer affording the 3/5 clause for the wealthy. Well, we need something new. And soon we had it, the corporate privileges, corporate personhood. There is a way to put kind of a logical sequence to the history. And I think that others should try to do it. But you're right, though. Most people in the communities don't have the time, for good reasons. Family and obligations and all of it, for sure. Also, their jobs, keep them tied up for most of their lives. Most of their waking hours are stolen from them. Most of the value of their labor is taken from them and turned into profit that is not something that they enjoy the benefits of. Because the system creates the process for that siphoning off of wealth, siphoning it up. It's not tricked down. It's really more of a gush up.
And
but people are psychologically not ready to change their minds.
Right. And it's in some cases it's offensive, where you would it's offensive to people listening sometimes that you're questioning the form of government too.
Yeah, I've been called names for sure.
Yes.
And accused of believing things that I just don't. But that's the way of the world. And it's not, I don't mean it's them, it's us too. You know, our liberal progressive friends are the least likely early on to embrace rights of nature because it challenges years and years of invested time, effort, and education into using the regulatory system that's been handed to us.
Right.
And there's a lot of resistance to changing strategy or tactics because it feels like an admission that, oh, I've wasted my time for 20 years fighting for environmental protections, new regulations. That's not my point at all. It's not wasted time. It's we didn't know that we were being scammed by the regulatory process.
Right.
When we find out, we should do something different, is what I would argue. And that's, in other words, I'm saying that people's hearts are in the right place. And by the way, that means people on the other side of the political spectrum, often their hearts are in the right place, but they have a different understanding of how things work. And their understanding leads them to conclusions that we find offensive, just as they find ours offensive.
Right.
We may all be wishing for the same thing, but we've been taught different lies, and we believe in different lies, and we fight each other instead of solving the problem, trying to treat symptoms and going after the actual root of the problem. And the root of the problem is minority privileges. And it's always, I mean, historically, that's the case. Whether it's done through, family bloodlines, hierarchies, aristocracies, feudalism, empires, and we have an empire, of course, based on property.
Right.
So yeah, and I would spend a lot more time to respond because that's an area that we should be talking about. How do we deal with people in communities? Let's come back to that in the future when we talk about.
Okay, I think that would be beneficial for CELDF and everybody that wants to listen. And,
right.
Yep. Thank you.
I'm going to wrap up with.
That makes
I'm sorry.
with a question, Ben, that is in chat. Have any of the jurisdictions, municipalities, countries, etc., that CELDF has assisted in passing laws to prevent corporations from violating their unalienable rights been sued in the World Bank or United Nations courts? I'm referring to corporations bringing cases against government entities for lost investor state rights.
None of ours have been challenged that way, not by international courts. Not by the neoliberal system of so-called justice internationally. It's only justice for property and wealth. And I did write about that, and we'll get to that in future installments. Not in a great bit of detail, but it is a real problem and it's a real issue. And when we draft our ordinances at CELDF, we began to include language that declared that the rights in these ordinances were not subject to challenge by international laws that elevate the interest and rights of corporate property. But that opens another large discussion, and I'll see if I can ask that we kind of defer that. It's coming up in a couple of chapters, if that's okay. If not, I mean, if we need to dwell on that and dig into it, but I think we can safely hold that off for a future discussion.
Thank you.
There's two more sections here, and we're running out of time, but I'll try to cover them pretty quickly here. And this next one is titled "Property's War Against You and Me. The Constitution Deputizes the Corporation." James B. Weaver was twice elected to the U.S. House of Representatives and twice a candidate for the presidency. In 1892, he wrote that, quote, the creation of corporations for pecuniary profit bears strong resemblance to the practice among nations for granting letters of marque, except that there is never any preceding offense to justify it. So a granting of a letter of marque meant that, for instance, the United States might give the captain of a ship a letter saying, you are authorized to attack British ships at sea because we're at war with them. Even though you're not a warship, you have our blessing, the United States Congress blessing, to attack British ships, whether they're warships or merchant ships, because we're at war. I'm going to move on a little bit. Powered by weaponized legal rights vested in property, the trend is leading us away from public governance of society and toward private dominion over everything. Schools, hospitals, highways, and prisons are all being privatized. Public land is auctioned off for exploitation with no benefit to the public. Water supplies are taken over by for-profit enterprises. Mercenary armed forces are paid with public monies. In the crosshairs for annihilation since they were first established are Social Security, Medicare, and other New Deal Great Society programs. The U.S. Constitution allows Congress to, quote, declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, end quote. At the same time, it forbids the states from granting letters of marque. Owing to the federal court's insertion of Bill of Rights protections into state-issued so-called contracts, the charters of private corporations have taken the place of those letters of marque, which once were issued to privateers in time of war, authorizing them to attack enemies of the empire. But are American people enemies of the empire? Perhaps because the Federalist plan of government was framed in hostility to commoners, this is the inexorable outcome at a time when the empire's global reach is contracting. When exploitation of foreign resources is slowed, an inward turn and the cannibalization of domestic resources, both human and natural, become inevitable. Exempted from obedience to local laws, corporate privateers now treat municipalities like resource colonies. Property's empire bloats temporarily as it devours its own. Like the charter of the British Empire's East India Company, against which American revolutionaries rebelled, court-ordered constitutional privileges for chartered incorporations of property have empowered privateering minorities shielded by corporate immunity to raid and acquire resources for themselves and help grow property's empire. Today's privateers raid foreign and domestic communities with impunity to gather their resources in an undeclared war of continued conquest against foreign and domestic communities. Still, we are wrong to blame corporations. They are the weapons, not the perpetrators. The true menace, and what must be exposed to a so far credulous population, to Dave Leidecker's point, is the privileged minority that sees humanity and life itself as resources for their enrichment. And the final section, pushing back, the people say, not so fast. In 2002, after discussing the way corporate lawyers stop municipalities from blocking factory farms and urban sludge dumping by threatening the local government with lawsuits for violating the corporation's civil rights, Mick Robertson, a local official in Licking Township, Clarion County, Pennsylvania, asked CELDF to write a law that would deny that corporations are persons with the same rights as people. And we did. And it became township law. Mick's simple question laid the groundwork for CELDF to include limitations and outright nullifications of corporate rights in every local law we've drafted since then. Here's an excerpt from the second CELDF ordinance adopted by Licking Township in 2010. Quote, rights of Licking Township residents secured by this ordinance and by other local, state, or federal law shall not be subordinated to the claimed rights, which are in fact privileges of state chartered corporations. Accordingly, public and private corporations that violate the prohibitions of this ordinance shall not enjoy privileges or powers under the law that make community majorities subordinate to them or have the effect of nullifying this ordinance. Nor shall corporations possess the authority to enforce state or federal preemptive laws against the people of Licking Township that would have the effect of nullifying this ordinance. Within Licking Township, corporations shall not be persons under the United States or Pennsylvania constitutions or under the laws of the United States, Pennsylvania, Licking Township, or any other law, and so shall not have the rights of persons under those constitutions and laws. It wasn't naivete. It wasn't hubris. We didn't pretend to have overturned the Supreme Court's rulings over the past century. What we began to do in 2002 and continue to do to this day is educate and inspire people to act on the premise that their unalienable rights are the highest law and the justification for government, as the Declaration of Independence makes clear. We knew that before we could challenge and defeat the Federalist counter-revolution, we would have to end their occupation of the American mind, to Dave Vladeker's point. That meant doing things everybody knows that we couldn't do. And that's the end of the text. And if we'd like to discuss anything further, we've just got a minute or two here, but I hope that the picture is becoming a little bit clearer as we go through a little bit more of the text of the book. That we're trying to point out that what the people that fought the American Revolution, the commoners, not the wealthy people who owned all the land, they didn't, by and large, they didn't fight the war. Yes, it's true George Washington led the troops, and he had a lot of land at stake. If we didn't break from England, he would have lost his claims to land in western Pennsylvania and southeastern Ohio. YH, what's your question or comment? You have your hand up.
Do you see the chat question?
Oh,
Yeah,
okay.
I forwarded it to you in hopes that it would be easier for you to see that, Ben. Do you want me to read it?
I see it. Thank you. Well, the book is where I don't focus exclusively on the organizing experience, but I do try to at least infuse some of a feel for it. We have a lot of information on our website, but there's no one volume that tells you how to do the organizing. Michelle and I have been working on kind of a self-guided PowerPoint that will be narrated, so there'll be a voiceover on it. That's a do-it-yourself community rights organizing. It's not complete. It's, we've got a lot done, but we hope to get that out there. So it will be available to anyone to download it and get down to some of the nitty gritty that Dave Lydecker, you were mentioning. It'd be great to get into that. So that it's not just about the law and where it came from, which is really how Wealth Rules focuses on, but how we've done the organizing at the community level. And just to be honest, we're constantly evaluating and changing some of that approach because the status quo privilege holders, they don't sit on their hands while we try to figure out what they've been up to. They generally develop new ways to thwart our attempts to get past their blockage of our freedoms.